Honorable members, please be seated. Honorable Minister, Culture, Youth and Sport. Seems like your colleagues abandoned you, man.
With good reason.
They don't want to hear the facts.
I would like to conclude. In the middle of what I was saying, Mr. Speaker, there was important parts of the bill that included judicial review, which was another piece of legislation, again monumentous, that was introduced by this People's Progressive Party government when in about 2014. It wasn't, just like this bail bill, it wasn't that judicial review didn't exist back then. It functioned under something called a prerogative writ. Certiorari and a number of the other mandamus orders that you can get, but became codified under this piece of legislation, which is important as we continue to move our country forward. So does the judicial sector needs to transform. And bail, as many people are unaware, and particularly office holders who are the ones in charge of the justice sector, they tend to forget that bail is only for the purposes of securing the accused, ensuring that the accused attends his trial or his investigation, essentially so that they don't flee, or in the rare instance where they may be harmful to other members of the society. Now, where once the accused has been charged with an offense, it also clearly outlines the instances where bail may be refused. And for the purposes of being comprehensive, I would like to state what in the explanatory memorandum has for clause 7. It says, in these circumstances, one is where the accused or the defendant would not attend trial, which is what I was referring to a moment ago. 2, interfere with evidence or the witnesses, or otherwise obstruct the course of justice. 3, commit an offense not punishable by fine while on bail. 4, be at risk of harm against which he or she would be inadequately protected. So those are the 4 areas that it outlines in clause 7, but it also says that bail may be denied where the defendant should be kept in custody for his or her own protection or the preservation of public order. Which takes me back to the original point that I started with, which was about the function and the role of the state, assuming the responsibility for security for the citizens of that nation, and quite importantly as well, in clause 8 of the bill, there were, especially in dealing with possession of firearms, in the Act, the Firearms Act, dealing with, and in one of the offenses that was created there, possession of a firearm did not attract the right to bail. In fact, once you were found with a firearm without a license, bail was refused, with the exception where they had this nebulous phrase called special circumstances, which was subsequently defined as in the case of Knights and the crews, as the Attorney General had also made reference to, where it was explained what those special circumstances were. And essentially, it said that those special circumstances were not that which were relevant to the offender or the accused. It was relevant particularly to the facts of the case. So that was important as a piece of case law, which lawyers refer to as common law, to explain what special circumstances mean in that situation. Importantly, this bill captures that. It explains what those special circumstances would mean so that for all of the acts that exist for which the term special circumstances relate to bail, the possibility of bail, how it can be explained, it is captured in this bill. So it is a piece of legislation that is monumentous. I am happy to share my voice on the passage of this bill, the support and passage of this bill. And I'd like to take the opportunity to commend this bill to the House. Thank you very much, Mr. Speaker.
Thank you very much, Honorable Minister Ramson. And now for the Honorable Member, Mr. Sanjeev Dattadin, for his contribution.
Good evening, Mr. Speaker. Mr. Speaker, I rise to support and commend Bail Act 2022 to this House for its consideration and passing. Mr. Speaker, I have been in practice for a little more than 25 years. And believe you me, Mr. Speaker, when I tell you, this undoubtedly is the most significant advancement in our criminal justice jurisprudence in all my years of practice. Bail is a right. Bail is a right that must be respected by all that choose or control the power to take it away. Liberty is a right. And all those public officials that exercise control or authority over your liberty must do so now in accordance with the Act. The Honorable Attorney General before me was quite diplomatic when he said that what happens is you would go to one court and bail would be granted for something, for an offense, any offense, and you'd go to another court half a mile up the road and it would not. It's worse. You'd go to the High Court and the same thing would happen. You'd go to the Court of Appeal, same thing. The reason, Mr. Speaker, was very simple. There was no equality of treatment for various reasons. Most of those reasons weren't nefarious. Some, of course, were. Most of those reasons had nothing to do with corruption. Some did. But the reason was very simple. There was no coercive set of rules that applied to everyone, that everyone could refer to. And in a jurisdiction where written reasons and decisions are not easily available, nor are they published frequently, essentially, judicial officers did not know what each other were doing or what principles were being applied outside of the very general principle. Mr. Speaker, this is a landmark day because all of that mystery, all of that opportunity is lost, and it should be lost forever. We do not want judicial officers and police officers at their whim and fancy and their mood and attitude grant bail, or more importantly, take away one's liberty. It is legislation that benefits an entire nation. God forbid you're involved in a minor traffic collision, and then you have to wait 3 hours for a policeman to decide on whether you would be placed on bail. And for about 2 hours and 59 minutes of that time, you're sitting in a chair across from him, and he's telling you that there's somebody he needs to speak to. And that somebody is waiting on a report from him, and he's sitting there doing nothing. Now, I know that might be an extreme example, Mr. Speaker, but the reality is the legislation now says very clearly, if the offense is not punishable with imprisonment, the person shall be placed on bail with every convenient speed. Now, these are words in legislation that have very specific meaning. It doesn't mean that the police can decide to wait on a superior officer. It doesn't give them that latitude or discretion. Convenient speed means the person has come to the station, you are aware of what the offense is, it is clear that the offense does not carry a custodial sentence, then you are to make arrangements to release that person. That is what it means. It means nothing less, nothing more. Now, in legislation, as you would know, Mr. Speaker, we use phrases like reasonable, we use phrases like in due course, due process, we use specific phrases. With convenient speed, Mr. Speaker, means that you do it as soon as you are aware. Now, Mr. Speaker, I commend the Attorney General, and I have told him this privately, and I wish it to be recorded, that it takes a lot of courage for a man in his position with his responsibility to put this in legislation for the protection of the people. Because he will be the one appearing before the judges to explain why policemen don't understand what he says by convenient speed. But Mr. Speaker, it is indeed what should happen. You see, not to get too technical, but at common law, a magistrate couldn't refuse you bail either if she couldn't or he couldn't imprison you. Magistrates and judicial officers need to understand, if the law provided for no imprisonment, they could not, through the back door, take away your liberty. So this piece of legislation gives effect to that. Now, if the offense is one punishable by imprisonment, unless it's a serious offense, the police obligation is as soon as practicable. Now, Mr. Speaker, that obviously is slightly different from convenient speed and a slightly lower standard because, again, it recognizes that it is an offense that is punishable by imprisonment. But it is not a serious offense, which is defined in Section 2 of the legislation as not carrying more than 5 years imprisonment. Again, Mr. Speaker, it does not mean that the police could go walkabout and treat with it at their convenience. Mr. Speaker, soon as practicable has a meaning. That is just very close and one step away from convenient speed. So, Mr. Speaker, these are important aspects of the law which may have been in diverse parts, but in this particular aspect of the law, it is an advancement. It is legislation that does what legislation is supposed to do. Protect the citizen's liberty. Paramount. Under all circumstances, it does that. Now, of course, Mr. Speaker, the legislation recognizes that they are serious offenses. And for that, there may be no bail granted. And they are serious offenses for which the police have to take you to a magistrate. And the Constitution provides they have 72 hours within which to do that. But this legislation, Mr. Speaker, allows you to take steps. If they're not serious offenses, if there is no imprisonment for the offense, you do not have to go through the lengthy process provided by the 72-hour wait and the rest of it of going before a magistrate. If you fall within what we would refer to politely as a minor offense, Mr. Speaker, it means that you should have your liberty. You don't have to wait for all the rest of things to happen. So you can't be asked to remain in custody in those circumstances by a police officer, because it is clear what the law says that his duties are and what he should do. Now, the legislation, Mr. Speaker, doesn't make it a free-for-all. What it does is it does what is sensible. It takes serious offenses, it takes offenses that are not serious, separates them, and treats with them differently. It takes capital offenses where the penalty is death, and it separates it again from this legislation. Because as the Honorable Attorney General mentioned, there is a framework of statute and case law to deal with those. Now, importantly, Mr. Speaker, Section 6 of this Act says everyone, there is a right to bail. So everyone has a right to be released on bail. When you are charged, serious, non-serious, as long as it's not a capital offense, that is, you are entitled to bail. But then it sets out what are the circumstances that should be granted for bail. Whether you fail to surrender to custody, whether you're a habitual offender, whether what you did you're likely to repeat, whether there are several such instances, whether it relates to protection of people, protection of the public. These are all things to be considered. And it is important, Mr. Speaker, that this be put in the law, so that it is not only lip service that is paid for it. So So the state, the prosecutors are not going to be able to turn up in court and rattle off an affidavit that says, we believe he's a flight risk. As the saying goes, believe in God and nothing else. If you know he is a flight risk, then say why. If you have information he is a flight risk, you must say so and what the information is, the source of your information. So the legislation, by setting these things out, that it has to be for someone's protection. Whose protection? What is the likely risk? So you're not allowed, as has been the practice for too long, that you regurgitate these things into affidavits without any foundation. This law makes sure or ensures that what happens is there is substance. Because now you have to demonstrate to the court, hearing the application for bail, that these things exist. So it's not merely to say so. These are the headings. You have to flesh them out and provide your evidence. This is important because far too often there may be uncertainty with judicial officers as to what are the matters and issues they are considering. Additionally, Mr. Speaker, there is consideration of bail pending appeal. And respectfully, I agree that the position must be there is no right to bail once you've had a conviction. But if you could show circumstances that are such, which are listed in the section, then you ought to be granted bail. Now, the special circumstances argument, which is a very vexed and troublesome issue in our courts, has always been whether it extends beyond the firearm offenses. The Act, as the Attorney General indicated, is where the interpretation comes from, special reasons. Whether it strictly applies to the Narcotics Act, because that refers to the same special reasons. But, Mr. Speaker, we now have it clear. Special reasons are relevant to the consideration of bail in all matters to which this Act applies. And it says it relates to the man, it doesn't relate to the man or the offender, it relates to the offense. These are important advancement in the criminal justice system because it means now that every citizen should be assured that these rights are what I have. You don't have to ask anyone. These are your rights. They are set out in black and white, and you're not at the mercy of anyone for them. Now, some of the legislation, as mentioned by the Honorable Member, Mr. Ramson, is a codification. And that is because it's been difficult, in many cases, to have the law all in one place, in one cohesive document. There's only one case that on the issue of bail that has reached the Caribbean Court of Justice from Guyana. There's only one case that has reached that court on bail in the entire Caribbean, as a matter of fact. And in that case, the appeal in the Caribbean Court of Justice, Mr. Speaker, I was counsel in that matter, and you'd be interested to know that the Honorable Member, Mr. Charles Ramson, was with me in that case, in the Caribbean Court of Justice. And Mr. Speaker, that was a matter from Berbice that found its way all the way to the Caribbean Court of Justice. It's Danpat. Kevin Danpat, was it Danpat and Mohammed, I believe. The citation is 2014 CCJ 9. But Mr. Speaker, the attorneys in Berbice who had done the matter was from Berbice, had made an error in the steps of the application. They had applied to the wrong court. And the reason was they didn't know. They didn't know that there was legislation that provided how it was. It wasn't easy to discover it because it was in bits and pieces of amendments. In fact, when the matter got all the way to the Caribbean Court of Justice, Madam Justice Barlow appeared for the state, and she indicated that it was a troublesome piece of legislation to locate. Indeed. But now, Mr. Speaker, no more. The process and the procedure is set out. You make an application to the magistrate's court, you're not happy, or either side are not happy, you go to the High Court, then the full court, then the Court of Appeal, and then the Caribbean Court of Justice. All the steps, very clear. Simplifying it, we even have the form for the appeal that has to go to the full court in the act, so it's a matter of filling it up. Now, this also involves amendment to what are really troublesome procedures that we would have experienced through the courts. If it was an indictable matter, you had to appeal to the Court of Appeal, and the bail application lay in the Court of Appeal. If it was a summary matter, the bail application had to be made to the High Court. These rules, which created havoc among young practitioners and experienced ones as well, and where you'd apply to the wrong court, etc., that's all gone. It doesn't matter which way it is. You go to the High Court judge, you go to the full court, you go to the Court of Appeal. The process is straightforward. There is the removal and the amendment by removal of legislation from the Court of Appeal Act that said you had to go to a judge in chambers as opposed to the full bench, which is a different application. So all of these pitfalls of procedure have been eliminated. All of them have been removed. The process is very simple now. In this simplified process, you can't make a mistake. From one court, you go to the next. It is not whether you go to the full bench of that court or you go to a single judge. Those things are no longer applicable. Now, one of the interesting things about the legislation, Mr. Speaker, is it provides for an appeal against the decision, and it provides also for you to make an application for judicial review of the decision. Two different prospects, two different approaches. The Judicial Review Act allows the decision of every public official to be considered by a superior court, a magistrate being a statutory body and an inferior court. Significant in the importance, Your Honor, is it's very difficult to appeal the exercise of a discretion. Meaning if a discretion is exercised as to whether it should be $100,000 or $200,000, unless you can prove that the discretion is so excessive that no other person would make that mistake, you're bound by it. Even if the appellate judges disagree with you, they would be bound to follow the discretion. There is no such limitation if you go for judicial review, because the discretion itself is reviewable. So, a vexed problem among attorneys and litigants and defendants and accused of how do you frame it to twist it to make it appealable or reviewable is no longer an issue. So, Mr. Speaker, this piece of legislation has taken all of the pitfalls, all of the chicanery, all of the little issues that denied justice on the basis of very frivolous grounds, such as procedure or not taking the right steps. All of that has been removed, Mr. Speaker. And as I said at the very beginning, Mr. Speaker, in my 25 years, this is the most significant advancement of the criminal justice system. It really is. and I commend it to this House.
Thank you, Honorable Member. Honorable Attorney General, you may conclude.
Mr. Speaker, I want to begin by thanking all of my colleagues who spoke so elaborately and comprehensively on the bail bill, outlining the merits and highlighting all the improvements to the legal architecture which are brought by this intervention. Mr. Speaker, what we are witnessing here, and it became very clear when I listened to the presentations of my colleagues so articulately expressed before this House, is considering the whole slew of bills which we have debated here this evening and we are not yet completed. Every single one of them, every single one is directed to the improvement of the rights and freedoms of our Guyanese people in a permanent, institutional, and systematic way. Every single one of them. So, Mr. Speaker, we don't have to run around the place and issue statements and pay lip service to concepts. We are actually delivering concrete materials to improve the life and livelihood of our people and to advance their freedoms and their liberties. That is what we are doing every single day. And it is patent and obvious in every single piece of bills, of legislation that we have promulgated here this afternoon. The opposition, who, as I earlier indicated, representing and paid to represent some 49% of our electorate, choose to absent themselves from these important lawmaking exercises, completely absent. Their constituents deserve better. Their constituents and this process ought to have benefited, all things being equal, from their contribution. Well, hopefully. Instead, despite refusing taxpayers, despite accepting taxpayers' money as pay to represent their interest in this House, they are home, or they are sleeping, or they are at Sweet Point, Bam Bam Alley, instead of being here representing the people interest in our country. So, Mr. Speaker, I hope, again, I take this opportunity to highlight to the people of this country the gross dereliction of duty on the part of the leader of the opposition, including the leader of the opposition. But yet you will hear them, as Minister Ramsden said, will jump on every housetop to say that they are championing the cause of the rule of law, they are championing constitutionality, and they are championing the legal rights and freedoms of the people of this country. They only do that to get the press attention and to pay lip service to those concepts. When to do real work to advance the people's welfare and interest in an institutionalized way, to put structures in place to guard against the very abuses that they are complaining against, they are absent. They make no contribution whatsoever. So, Mr. Speaker, when we speak about allegations of police excesses and we condemn those excesses, whether rightfully or wrongfully. What we are doing here, what we are witnessing here, is a menu of laws establishing systems and permanent structures in our legal architecture to guard against, to prevent, and to prohibit those types of abuses. That is what we are working for. Working every day to put systems in place to ensure that those things do not happen. All that they do is sit idly by, do nothing. But when those things happen, they jump upon every housetop, exploit it for political advantage, and make political mileage out of it, with no concern for either the victim or the perpetrator. No concern to correct the system. Were they concerned in correcting the system, they would have been here contributing to this debate. They are not here. I say that again to remind the people of this country of the type of representation that they are receiving or its lack thereof from the neglectful politicians they have elected to this house. And I hope there's another election coming within the next few months. I hope the people of Guyana and the electorate will register their protest and their sanction and their disgust and contempt at the neglect that they are facing at the hands of these honorable members of this assembly. Mr. Speaker, I want to also thank Justice Charles Ramson, Senior Counsel, and the former Attorney General for guiding discussions and for a direct inputs made in this bill. As a lawyer since in the early 80s, Mr. Ramson wrote an article titled Bail or Jail. And since then, 40 years ago, he lamented the absence of a statutory framework for the grant of bail. And he highlighted the excesses and abuses which take place, in particular at the police station, in relation to bail. In his book, Portrait in Justice and Liberty and Equality, he revisited that article, which he wrote 40 years hence, and commented again on the failure to have this statutory mechanism in place. And what he wrote in that book and in that article have been embraced in this bill and now forms part of the legal architecture of our country. Mr. Speaker, I know my drafting team is here, and I have not paid compliments to them as yet, but we have another bill, and I don't wish to be repetitive at this late hour. So, Mr. Speaker, I conclude by commending this bill to this Honorable House to be read a second time. Thank you very much.
Thank you, Honorable Attorney General. Honorable Member, I put a question that the Bail Bill 2022, Bill number 14 of 2022, be read a second time. Those in favor say aye. Those against say no. Ayes have it. Let the bill be read a second time.
Bill 2022, Bill number 14 of 2022.
Honorable members, the House will now resolve itself into committee to consider the clauses of the bill. Honorable members, the bill has 32 clauses and two schedules. I now propose a question that clauses 1 to 32 and schedules 1 and 2 of the bill form part of the bill. Honorable members, I now put the question that schedules 1 to 32, clauses 1 to 32 and schedule 1 and 2 form part of the bill. Those in favor say aye. Those against say no. Ayes have it. Clauses 1 to 32 and schedules 1 and 2 are now part of the bill. Honorable members, I now put the question that the Bail Bill 2022 be reported as printed, be reported to the Assembly. Those in favor say aye. Those against say no. Ayes have it. Let the Assembly resume. Honorable Attorney General.
Mr. Speaker, I rise to report that the Bail Bill 2022, Bill number 14 of 2022, was considered in committee clause by clause and passed without amendments. I move that the bill be now read the third time and passed as printed.
Honorable members, I put the question that the Bail Bill 2022, Bill number 14 of 2022, be read a third time and passed as printed. Those in favor say aye. Those against say no. Ayes have it. Let the bill be read a third time.
Bail Bill 2022, Bill number 14 of 2022.
Honorable members, we will now proceed with the second reading of the Narcotic, Drugs, and Psychotropic Substances Control Amendment Bill 2021, Bill number 2 of 2021, published on the 28th of January 2021. Honorable Attorney General and Minister of Legal Affairs, Mohabir Anil Nandlal.
Thank you very much, Mr. Speaker. And I commence the last leg of this marathon session. Or as my chief whip is advising, she prefers the term last lap. Mr. Speaker, in any given society, there are areas that require policy directive and legislative intervention where there are competing and colliding interests. Guyana, as we know, is a land of 6 peoples, different religions, different ethnic groupings, different social orientations. And in a society like Guyana, you have competing interests in relation to many things. The bill that is before us addresses the question of the use of narcotics in our country, in particular the use of marijuana, and it seeks to change the current law in respect thereto. Many governments in the past in Guyana have tried or have made commitments to tackle this very vexed question. In fact, This was a campaign promise of the APNU AFC at the 2015 general elections. They promised decriminalization of small quantity of marijuana, and they made that a high priority promise in their manifesto. When they took government, a bill to that effect was drafted and laid in the National Assembly, but died a natural death, never debated. My Minister of Health is advising that it's an unnatural death. I stand corrected. He died. Whether naturally or unnaturally. We made a promise, Mr. Speaker, in our manifesto and in our election campaign in the 2020 elections, that we will decriminalize, not decriminalize, we will remove custodial sentences from small quantity or small quantities of marijuana. We made that promise. And we were elected upon that manifesto, which contains this promise. Mr. Speaker, today we are delivering on that promise. But the journey that we traveled to arrive where we have arrived today has not been an easy one. We believe in a process that is as consultative as possible. And on an issue like this, which has a history of being controversial, where you have different segments of our society, all of whom are entitled to equal treatment, all of whom are entitled to fair treatment, all of whom are entitled to their peculiar and idiosyncratic interests being addressed by the state, but where they are competing, we will have difficulties. A responsible government has to therefore skillfully navigate these competing interests in an effort to find that delicate, acceptable equilibrium in order to satisfy or placate or pacify, while at the same time accommodating these viciously competing interests. And that is the task that had to have been undertaken in relation to this bill. And we have to speak it and confront it because people are listening to us whose interest in this bill may not be reflected in the manner that they would have liked. Brother Bob Marley said, you can't please all the people all the time. At least try to please some of the people some of the time. So we have one segment of our population, for example, the Rastafarian movement, who believe that marijuana is part of their divine practices, it's part of their religious practices. Freedom of religion is guaranteed by our Constitution as a fundamental right and freedom. And they believe that this is a product of the Creator. Haile Selassie, Jah Rastafari. That is a herb, a plant. As one comedian said in America, it's a plant, but if it catches fire, if it catches a fire, it has some consequences. Then you have the other segment of our religious society who feel strongly that this should remain a prohibited substance. One of such denomination describes it as a forbidden tree. And that it causes, or the use of this product causes wanton familial and social destruction in our country, leading to crime, joblessness, homelessness, etc. And then you have another set in our society, upper and medium class, middle and upper class, some of whom are smoking but keeping it a secret, but they would not enter the fray because they don't wish that to be known, but they are following the debate nevertheless because they have an interest in the outcome. The distinguished Foreign Affairs Minister is smiling. I am not attributing anything to the honorable member. Mr. Speaker, as a government, we have to take all these competing interests and try to strike that balance. And that is what is captured in this bill. For not a moment do we, on this side of the house, think that we have come up with a perfect output. No, we haven't. What we have tried to do, and that is all we can do in the circumstances, is to try to strike an acceptable compromise. And in so doing, we have looked at North America, where marijuana is now legalized in many states in the United States of America, at least small quantity for own use. We have looked at Canada, where the same obtains. We have looked at those countries and other jurisdictions, modern jurisdictions, where the medicinal value of marijuana is recognized and very much sought after. We have looked at the Caribbean that has, like Guyana, been grappling with finding a compromise because of the widespread use of marijuana in this region. We have examined a report commissioned by the CARICOM heads of government, titled The Report of CARICOM Regional Commission on Marijuana 2018, a comprehensive report on possible reforms to the law regulating marijuana in CARICOM countries. The heads of government at CARICOM commissioned this report because they, at some point in time, were facing and are facing the situation that we are confronting here tonight. This is what the report says. The heads of government were deeply concerned that thousands of young persons through the region had suffered incarceration for marijuana use and consumption, and many, after their first experiences with the law, resolved to continue with crime as a way of life. Inconsistent applications of the law had led to deep resentment and non-cooperation with law enforcement agencies. This is what the CARICOM report is saying. Mr. Speaker, these are some of the very sentiments that informed our position. Currently, the law says that if you are found in possession of small quantity of marijuana, you shall be sentenced to a term of imprisonment between 3 to 5 years. And we thought that it was simply wrong to condemn our young people in particular and our citizens across the board to such a harsh and potentially destructive penalty of 3 to 5 years in prison for the use of small quantity or quantities of marijuana. In 2014, the said CARICOM heads of government in their 2014 meeting, which established the Marijuana Commission, resolved to proceed with care, mindful of the need to capture the complex, multifaceted, socio-economic, legal dimensions of cannabis, marijuana, legal policy, and to divorce this sensitive issue from political partisan stronghold that often accompanies calls for change. This is an admonition from the heads of government of CARICOM to tread carefully with a very complex issue. Mr. Speaker, it is for that reason that though our manifesto made a promise in broad terms, we didn't agree on the quantity. We promised the principle, the skeleton, but we didn't promise the flesh. We drafted a bill here and we made it clear that it is simply a proposal which we planned to send to a select committee and charge that select committee with the directive to do public consultation. So on the 28th of January 2021, we transmitted a bill to a special select committee with the instructions to get the benefit of the widest possible consultations and views on this issue, which, as I said, has indeed evoked disparate and deep-rooted sentiments. Mr. Speaker, that select committee comprised of 5 government members and 4 opposition members. We met on a number of occasions, and there's a report that has been presented to the Assembly. The work of the committee spanned over a year, and most of the time was spent soliciting and enlisting public recommendations, advice, and interactions on the bill, which we made public and invited presentations in writing in relation to proposed amendments. We received submissions both from organizations as well as many persons. And I want to put on the record of this debate, at least the organizations with whom we interacted during this consultation process. The Bar Association of Guyana, 12 Tribes of Israel, the Guyana Rastafari Council, Theocracy Order of the Nyabingi, Healing the Nation Theocracy Party, Roger Edmondson Foundation for Herbal Rights, Assemblies of God in Guyana, Guyana Ahmadiyya Anjuman Aisha at Islam, Lahore in bracket, the Central Islamic Organization of Guyana, the Guyana Islamic Forum, and the Guyana Hindu Dharmic Sabha. These organizations made submissions, and as I said, made submissions of a competing nature, which the committee then had to decipher and then arrive at what the committee thought were consensual or compromise position, not consensual. And that was the process that we engaged in. As I said, the committee used the marijuana report of the CARICOM for guidance. That report pivotally understood, and I quote, the determination of whether or not the status quo with respect to the legal status of marijuana deserves to remain or to be changed necessitates a deep inquiry into the several multidisciplinary dimensions of the subject, the scientific, medical, legal, social, religious, and economic. And that is the type of inquiry that the committee sought to embark upon. We looked at the entire Caribbean, and the Caribbean is moving in this direction. There are some jurisdictions where very small quantities have been decriminalized, and they are the hybrid position where it is still a crime, but custodial sentence has been removed. And Mr. Speaker, we decided to strike the balance whereby we are in this bill removing custodial sentence from 1 to 30 grams. Custodial sentence is removed, but it still remains a criminal offense. In respect of 1 to 15 grams, the penalty is counseling, mandatory counseling. And from 15 to 30 grams, the penalty is community service under the Extramural Work Act. That, Mr. Speaker, is the crux of this amendment. Everything else is consequential. As I said, Mr. Speaker, we did not arrive at this position lightly. We debated, we examined so many examples, so many jurisdictions before we came to this position. To understand what is 30 grams, the committee requested the assistance of the distinguished Minister of Home Affairs to use his ministerial connections to get for us from Kanu a quantity of the substance so that the committee can have a good look at what 30 grams is or are, or what 15 grams are. That is the type of detail which inspired the work of the commission. Mr. Speaker, as I said, the opposition, as is their norm, hardly attended the meetings. I think we had to issue public statements criticizing them for non-attendance. And it is reflected in the report. And when they attended, they did not have much constructive contributions to make. Then while the committee was ongoing, Duncan, one member, he was suspended. In fact, the report, we had to send it around, the bill, the last version of the bill. They were not coming to the meetings, and we enlisted the cooperation of the clerk of the committee to send the bill around one final time for their input. Of course, nothing came. So, as we are trying to navigate these difficult questions, we are not getting any help from the opposition. But they will be the first to condemn what we have done, if they have not begun to do so already. But they were part of this committee. Let them show what they did. I know that they promised decriminalization of small quantity of marijuana, which they never delivered. We are delivering what we promised. We never promised decriminalization, and I want to make that very clear. We promised the removal of custodial sentence from small quantities of marijuana, and that is what we are delivering to the people of Guyana tonight. And again, Mr. Speaker, I want to highlight the track record of the People's Progressive Party in delivering promises that it has made to the people of Guyana. And that is important in the realm of politics in particular. In contrast, not only you have an opposition who do not deliver on their promises, but they sign agreements and enter into arrangements that they later repudiate. But there's a whole another debate altogether. So, Mr. Speaker, we have taken the bull by the horns here, and we have put forward a formulation to address this issue, this vexed issue of possession of small quantities of marijuana, in a manner that we think accommodates in the most compromising way the competing, disparate, and different interests within the four corners of our society. Jamaica may have a different experience and a different cultural and religious makeup, and they obviously would be guided by that. So would be Barbados. So would be Trinidad and Tobago. So would be the other smaller islands in the Eastern Caribbean. And in fact, they have moved in that direction. And their formulation has nuances that obviously are potentially were potentially nuanced, were carefully nuanced rather, to meet the peculiarities of their society. We are doing the same for our society. So what you see here, Mr. Speaker, is a position that reflects our attempt at finding a compromise on a very contentious question. Mr. Speaker, without any further ado, I commend this bill to the House. I thank you very much.
Thank you very much, Honorable Attorney General. Our next speaker will be the Deputy Speaker of the House.
Thank you, Mr. Speaker. I first want to thank the Honorable Attorney General and his team for tabling this piece of legislation in this House. And I want to ensure that the people, once again, that are listening to this debate understand, as the Attorney General so aptly put it, the balance that needs to be struck between what society needs and what some of the other competing interests want. Mr. Speaker, I have, much like many of my colleagues on the other side of the House, been around to very many communities. And there are a lot of fears. In those conversations, you hear about the potential destruction to the young minds, the somewhat lethargic nature that sometimes ensue after one smokes marijuana. You listen to their concerns about how it's going to affect their small communities. And I have seen some of the effects, having lived in Canada for a while, country that has legalized marijuana. I have seen and I have personally experienced within the work environment some of the restrictions that comes with legalization. And I offer my own profession as an example to demonstrate or to let the world and this country know about the technicalities of legalization coupled with one's profession. In aviation, imagine you have a pilot that deals with legalization, hops in the cockpit and decides that they're going to take off, except that their response time has been degraded and any aircraft that you fly has to perform to a certain specification, and you suffer from a critical emergency, critical failure, and you sit there and it takes you literally seconds, very, very important and critical seconds to respond to certain emergencies. It creates a limit to what one can achieve if you were to go down a path where cannabis becomes legal. Imagine doing the maintenance on an aircraft, maintenance on a car, and because the person becomes a little bit lethargic, maybe a little bit laissez-faire, they fail to tighten up some screws, maybe fail to secure a brake line, the effects that comes with that. Imagine someone in surgery, a surgeon, saying, you know what, I'm going to go and smoke because it's legal, and I'm going to go and perform a surgery. What this bill does, Mr. Speaker, is that it puts the brakes on people who may otherwise be overzealous in wanting to use marijuana and think that the same professional environment exists to them. That's one. The second, and in my humble view, one of the more important things, is that it keeps people who want to consume small amounts of marijuana out of jail. It is something that we have seen repeated over and over, where someone is caught smoking a small joint, and instead of addressing it through some community service, that they're sent to jail. So essentially what the system would have done historically is to send young offenders to jail to become hardened criminals. You're going to jail to graduate as a full-fledged hardened criminal. And I think what this bill does, Mr. Speaker, it balances societal needs. It may not be perfect, as the Attorney General has said. I quite agree with him on that. It is my sincere hope that people who consume, who smoke, that they don't look at this as the final step. And I borrow from the words of Neil Armstrong when he landed on the moon. This is one small step for marijuana, a large step for the Rastafarians, not that I can speak on their behalf, but all of the other young people who otherwise would have been caught in a trap where they walk into jail and come out hardened. And I want to ensure that the Attorney General understands that he has my full and complete support on this bill. And once again, it may not be the final resting place, but I look forward in the future to what revisions will ensue as society evolves. Thank you, Mr. Speaker.
Thank you, Honorable Deputy. And now for the contribution of the Honorable Minister of Home Affairs, Wilson Horatio Ben.
Thank you, Mr. Speaker. Mr. Speaker and honorable members, I want to join the debate, the discussion, as it were, on the question of the Narcotics, Drugs, and Psychotropic Substances Control Amendment Bill 2021. And in so doing, I want to congratulate the Honorable Minister of Legal Affairs and Attorney General Anil Nandlal for the work that he put in, particularly at the level of the committee on which I serve too, in respect of coming to a determination after the various consultations which he mentioned in respect of arriving at consensus, as it was his position on this matter. Of course, the work of the committee was too long, disruptive, dysfunctional, largely because of either the lack of attendance by the APNU AFC members who were members on the committee, and in spite of the dignified presence of the support staff from the embassy, from the parliament, and in spite of our being there on many occasions and having to wait, minimal work was done on many of the days when we attended. Mr. Speaker, I want to confirm as the Honorable Anil Nandlal uh, did, and to support the position that it is not a decriminalization of the use of marijuana or ganja as it is commonly known in Guyana, but that the step has been taken to have counseling for persons who may be found with small quantities, 0 to 15 grams, and for those beyond 15 to 30 grams, community service. Beyond that, the penalties which are already in the law remain. It would not have gone unnoticed to most of ourselves driving around the city or going to certain events, perhaps, to see that there is apparently a much greater increase and open public usage of marijuana. And in fact, the work of both the Guyana Police Force and the CANO, much of the work now is not only being done in respect of the areas where it is being grown on the Burbridge River and the Kanji, behind Ituni and other places, while much of the work, as we understand it, is being done to create products for shipment to other countries. The result has been by a lot of frequent use of marijuana, particularly amongst young people, and perhaps too amongst the more defiant criminalized or semi-criminalized elements in the city and the villages, the bad fellows. The Honorable Attorney General referred to other jurisdictions where there are differences and perhaps more permissiveness and decriminalization, to use the word loosely perhaps, in respect of the use of small amounts, sometimes large amounts compared to the total you're speaking of now, of marijuana. The suggestion from persons in the society about the medical usage, the benefits, and so on, are far outweighed by the interventions which have to be made by the state, both in terms of the criminal justice system and in respect of the responses the medical and psychiatric counseling services have to put in place in terms of rehabilitation in respect to those who would have started with a precursor drug such as marijuana and who would have gone on to cocaine, heroin, methamphetamines, and many of those other things which are now available, including the synthetics, of course. And of course, we know the big problem in the United States where there is a lot of death and disruption as a result of the use of certain synthetics and other drugs, which created a big medical and social and economic developmental problems in certain areas in the United States particularly. It is not my personal view that the use of these drugs is a good thing. And I disbelieve that there is any benefit really to it in Guyana itself compared to other countries We have a still poorer society. We have a lot of poverty. We have a lot of people who are away from their homes, particularly men in stressful conditions in the farms, in the mines, in the lumber, uh, the forest concessions, and all kinds of other places. And the behavior nowadays seems to be that if you want to distress beyond drinking alcohol, or you would partake in marijuana, you would partake in drugs. And if you want to stamp and enjoy yourself, the best way to do it these days is by the use of illegal narcotic substances. The result has been, as we know traditionally, that when people use alcohol and narcotics, that they have or they create for themselves the excuse, the Dutch courage we speak of, to cover up for bad behavior or to make use of it as the excuse for disorderly conduct, for getting into fights and disruptive behaviors and using knives and guns and so on each other. Gives them the strength, the courage, false of course, to conduct deliberate criminal acts. So generally, I would say, and we have the experience, we had a situation of someone called Baby Arthur in Buxton, who killed a number of people after drugging up himself on cannabis, sativa, marijuana. Uh, and there are many other examples. So, marijuana itself is a precursor drug. We talked about hemp itself. I remember as a young fellow going to the shop in Ogle, where it was sold openly in those days across the county in the shops. And then it kind of died away. Things got better. It was normal, kind of. But then people lost interest in it and it wasn't being used anymore. There was a resurgence in the 70s and 80s. Uh, I think more or less driven by issues related to tourism in the Caribbean and perhaps the continuing interest in increasing and moving the levels of decriminalization in the Caribbean has to do with the foreigners who come to Barbados and Jamaica and other places to enjoy the big spliffs uh, in those countries. And I must say, one of the issues with the use of marijuana has to do with the potency of it. Even in Guyana now and recently, we discovered and tossed out of the country a Jamaican who was supposedly bringing in new strains of the substance. There's new strain from Colombia and the new strains from Jamaica. And they're not concentrated on the leaves, but on the buds, which have much higher potency than what the normal user in Guyana is expected or taught to use. But because it is now the production in Guyana, most of it is directed towards exportation into the Caribbean and over into Suriname. But speaking again about the precursor element beyond marijuana itself, the question is where do we go from here, even while we support uh, the resorts to prevent more or many people, young people particularly, from being imprisoned as a result for having in possession small quantities, now move from 15 to 30, and with respect to avoiding doing community service, but I just wanted to say a few things about the question going forward. If we do think beyond protecting public health, that the even in Canada itself, where the deputy speaker spoke of from issues relating there, that where there's decriminalization for small amounts of marijuana. But beyond that, if there's small amounts, you get what they call tickets for being over the limit, the penalties. Up to 5 years in jail or less a day, up to 5 years less a day in jail for being over the limit that they prescribe. For illegal distribution or sale, tickets for small amounts up to 14 years in jail. Producing cannabis beyond personal cultivation limits, tickets for small amounts up to 14 years in jail. Producing with organic solvents up to 14 years in jail. Taking cannabis across Canada's borders up to 14 years in jail. Giving or selling cannabis to a person under 18, again up to 14 years in jail. Using a youth to commit a cannabis-related offense, up to 14 years in jail. And then, of course, there are further and similar penalties with respect to LSD, heroin, cocaine, and psilocybin, magic mushrooms. So, while we contemplate and we accept here and now the result we have with respect to reducing incarceration, getting the counseling for young people up to 15 grams possession, and community service for up to 30 grams, we have to consider legislation and issues beyond what we are resorting here and now. The containers of both the police and the canoe right here and now are filled with bundles of marijuana, dried, processed, which they have captured along with guns too that they have seized from the persons who are involved in the trade. I would still say, and I want us to remind ourselves that when the sugar estates were shut down in Berbice, both the quarantine side and on both sides of the Berbice itself, the impact that has had has allowed people to get in more exotic forms of agriculture, the agricultural interventions, the plant husbandry, and all of those things are perhaps at the highest level amongst those persons who are growing ganja in Guyana. And our Honorable Minister of Agriculture, I think, is under some serious competition with respect to matching up the effort they are making in that endeavor. So I hope, and we've been talking about encouraging some of those people to go to some other, give them the seeds, the planting the materials to grow cabbage, cauliflower, tomatoes, and other things as a replacement to that which they're doing now, but to get livelihood and money coming in, and that we're working to break down the criminal links, those who are deeply involved in the trade at this moment. So, and it would also to be true to say that some of the most heinous crimes which are occurring are as a result of disputes, contests, uh, lack of trust in respect of the trade. And the significant problem of the blocking of roads related to murders of youths on the West Coast Babies when we, shortly after we took office, by our understanding, is related to marijuana issues gone wrong. Had nothing to do with politics, had nothing to do with problems between communities. It had simply to do with issues related to marijuana crops, the cultivation, the distribution of assets related to marijuana. So I also wanted to say that. But with all of that, Mr. Speaker, in concluding, I want to particularly in his absence praise the Honorable Attorney General and Minister of Legal Affairs, Anand Nanal, for his efforts, his insights. In spite of some related opposition and criticism on the matter, because it's not all well fully settled, even on our side, but this is where we are now at the point of consensus, for his work, and particularly too for the work of his legal support team from his ministry, and also to thank those who were positive in support at the level of the committee, which was examining this matter uh, at the behest of the parliament, and to forget the contribution from one particular member from the other side who suggested, Honorable Member Anil Nandlal, that the amount, the amount of marijuana which should be permitted should be, I think, 3,000 grams. 3,000 grams. That was the contribution from the AP and AFC. At the committee stage, 3,000 grams, which is about 7 or more pounds. So, with that and on that note, I want to again join on the issue, look forward to our further development of the best and most efficacious way to approach the question of the use of marijuana in this country and how we deal with it in a legal and proper way. And I want to commend the bill to the House. Thank you very much.
Thank you, Honorable Minister of Home Affairs. And now for the Honorable Minister of Culture, Youth and Sport, Honorable Charles Ramsey.
Thank you very much, Mr. Speaker. I want to start by letting everybody in Guyana know that this is not an easy debate. It is not an easy decision or position for anyone who's involved in government to take on behalf of the people of the country. And there are very strong views on either side of the debate, or the many sides of the debate in this regard. There are some people who feel that the penalties should remain exactly the way that it is. There are some people who feel that the penalties should increase. There are some people who feel that there should be no penalties at all for the use/possession of marijuana. And there are a number of views that fall anywhere along the spectrum that I've just outlined. Now, very important for us to trace the history of what we know in the world as the war on drugs. It's a phrase that was coined sometime around 1971 in the period of Richard Nixon, where it became the policy of the government of the United States of America, an established position where they wanted to make this a universal fight, the war on drugs, that took it to many other countries in the world. But prior to that, it must be noted in this debate, especially amongst the older generation, where you would find a more common view that there should be no changes to the harshness of the penalties in relation to the possession of marijuana, or that they believe that it may be not harsh enough. But prior to that period in 1971, there existed no war on drugs. In fact, you may be very familiar with the term hippies. You would also be very familiar with the word psychedelic. And it wasn't that these drugs, and particularly marijuana, it wasn't that they didn't exist prior to this war, so-called war on drugs. They existed for as long as human beings have been alive. It has been used by human beings for hundreds, probably thousands of years, or maybe even more, but there's no record to say how long it has been used. In fact, in many cultures, it forms part of their rituals. That's correct. That is the right word. Their rituals. Many times when, even today, in other parts of the world, if you're looking for answers about your life, about your children's life, and what's wrong with you, you would go to a quote-unquote doctor of the village. And he would consume some things and start to prognosticate and diagnose in all kinds of terms and tongues. I'm saying this because I wanted to trace the history of the criminalization of the possession of drugs.
Honorable Minister, apparently someone doesn't like you. You have no quorum. Again. I'll take a short suspension.
We are a peaceful people. Struggle is we struggle, and we don't look for trouble. Just ask around. But when outside faces from foreign places talk about taking over, we ain't backing down. We ain't giving up no mountains, we ain't giving up no tree, we ain't giving up no river that belongs to we. Not one blue sake, not one rice grain, not one karage, not a blade of grass. This land is all I know. We gonna make it somehow. We will bend like a bow and never break. Our fathers came here and they lived and died here, and we ain't moving nowhere. Make no mistake, 'cause we ain't giving up no mountain, we ain't giving up. We ain't giving up no tree, we ain't giving up no river that belongs to we. Not one blue sake, not one rice grain, not one karage, not a blade of grass. We love the open country of the Rupununi and the Essequibo, daytime or night. Though we may criticize it, this is our home, we love it, and we need to keep it. We have that right. So we ain't giving up no mountain, we ain't giving up. We ain't giving up no tree, we ain't giving up. We ain't giving up no river, we ain't giving up. That belongs to we. Not one blue sake, not one rice grain, not one karage, not a blade of grass. So we ain't giving up no mountains, we ain't giving up no tree, we ain't giving up no river that belongs to we. Not one blue sake, not one rice grain, not one karage, not a blade of grass. We are a peaceful people. Struggle is we struggle, and we don't look for trouble. Just ask around. But when outside faces from foreign places talk about taking over, we ain't backing down. We ain't giving up no mountains, we ain't giving up no tree, we ain't giving up no river that belongs to we. Not one blue sake, not one rice grain, not one karage, not a blade of grass. This land is all I know. We gonna make it somehow. We will bend like a bow and never break. Our fathers came here and they lived and died here, and we ain't moving nowhere. Make no mistake, 'cause we ain't giving up no mountain, we ain't giving up. We ain't giving up no tree.
Honorable members, please be seated. Honorable Minister, Culture, Youth and Sport. Once is an accident, but twice, I think they're doing this deliberately. You may continue.
In conclusion, I would prefer to have stuck with that, but I can't on this instance. because I feel that this is an important piece of amendment that the country requires that explanation. And in relation to one of the strong issues that we gleaned when we were in opposition, and actually even for the entire period before we went into opposition, just before we went into the opposition, it was something that was being hotly debated amongst young people. So I left off, Mr. Speaker, where I wanted to trace the history of when marijuana became a crime. The possession of marijuana became a crime in Guyana. And not surprising and consistent with what I outlined earlier, which was the war on drugs that emanated from the United States of America under the Nixon period. You would see that in the Narcotics, Drugs, and Psychotropic Substances Control Act, Chapter 10:10, you would see the year when it was first passed. It was in 1988. And why that's important is that marijuana had existed in Guyana and used in Guyana decades, many decades prior to that. In the world, it was also being used decades, many decades prior to that, without anybody identifying it as a substance, first of all, that required the creation of an offense that can put people into incarceration until that policy that emanated from the United States of America. Now, over this period of time, you would have seen since that 1970s period, and then in Guyana when it was first established in the 80s, the world has gone through an evolution in its willingness to adopt a more enlightened approach to whether it ought to keep drugs as an offense, particularly marijuana as an offense, and to start to study what have been the consequences of its use, and also whether the institution of and the creation of the offenses have caused its decrease. So for the folks who are very strong on the position to say that nothing should be done in relation to the harshness of the penalties, or for the folks who think that the penalties should be harsher, we are about to amend this law, not to decriminalize it, which is important that I establish that, but we are about to amend this law that existed since 1988. And this law that very clearly said that drugs, marijuana fell into the category of a narcotic, that possession of it was punishable by an offense of which one of the penalties was imprisonment. So taking away your civil liberties. And what has been the consequence of that creation of the offense? It didn't eliminate the use of drugs. It didn't eliminate the use of marijuana in Guyana or any part in the world. In fact, if penalties alone had affected whether there was a commission of an offense, and and it's something that I spoke about in one of the debates that we had. If the creation of penalties and just the sheer harshness of the penalties had affected whether a particular act continued, then there would be no murder. Because the most or the harshest of all penalties is when the state says it will take your life. And even though the death penalty is not used in Guyana, and this was maybe within the last 30 years or so, it hasn't been used. The last one, I'm being advised by Minister Tashir, the last time was in 1998. In other parts of the world, the death penalty still exists. And the reason why it is used, it is because that act that was categorized as an offense for which the consequence is death if convicted, the reason why it is used is because those acts still occur. The commission of those offenses still occur. So just from the sheer point of view of logic, for the ones that are on the side of the debate that Guyana should not start to examine what position we take as to how we can protect our citizens in the best way, for which every government has overall responsibility, and you have to balance all of the interests. So while we are not being laissez-faire or cavalier, insouciant about the welfare of children or young people or people who are interested in possessing/using marijuana, we also have to examine very carefully what everyone else in the world is doing. We also have to examine very carefully whether the measures or policy that we implemented, whether it's fit for purpose and whether indeed it was working as intended. There are many locations where billions of dollars is spent on the fight on drugs. Billions of dollars spent on the fight against drugs. And that war has never ended. It doesn't mean that you should stop fighting. That's not why I'm making reference to it. But if we have to protect young people in the country in this regard, for which particularly I couldn't conclude the debate. If we have to protect young people, we cannot punish them by putting them into a prison because they are in possession of a joint. We cannot do that. That is not protecting them. Exposing them to the same kind of criminality that exists in prisons, surrounding them with persons who have done far more serious crimes. That is not the way that you would get the best response in treating with this issue. And it is very important that in examining this enlightened approach, we also examine what other places have done. We know very clearly that what other places in Europe have done. We also know what other places in the US and Canada has done. But I wanted to examine as well what closer to home, places where they're of a similar culture. What has been their approach to examining their respective policy position in their laws? So I wanted to share some data, some information about other countries, just for the sake of reference and for completeness, as far as providing the public with the information that they need so that they can know that this was not an easy decision for us. This was not an easy position for us to take. And that we're not treating with the issue in a cavalier or insouciant way. Trinidad and Tobago, they have decriminalized the possession of drugs, of cannabis for 30 grams or less. Decriminalized. In Jamaica, it is 56 grams that is decriminalized as well. In Antigua, they also decriminalized up to 15 grams. Belize decriminalized up to 10 grams. Dominica decriminalized up to 28 grams. And I'm sharing this with you, Mr. Speaker, with members of the House, with the public at large, just as a reference point. What is the distinction in Guyana? Not in relation only to the quantities, which ours ranks amongst the lowest, is that we haven't decriminalized. We haven't decriminalized. Now, it's not that that this is the final position for the country, but we also have to take a responsible position because we're not willing to experiment with the lives of young people. We're not willing to experiment. Just like my learned friend and honorable member, Minister Robeson Ben, I also share his view that there is no beneficial, and this is my personal view, that there is no benefit for the use of marijuana for casual purposes. There may be some medicinal purposes like glaucoma. There may be some benefits for the usage there. And I'm also extremely concerned that for the stronger strains of marijuana, commonly referred to as skunk, that some people, young people, if they're exposed to it, that it can create cognitive issues that linger. So in rare instances it happens, but I'm aware of it, and I'm also mindful of what that can do, but I don't believe that driving it underground makes it easier for us to engage with young people to explain what are the dangers. Because we've all been there at some point where we're young and willing to be rebellious or experiment, and even though I have never experimented with any kind of narcotics, and I wanted to state that on the record, never tried. I can't say that I can speak on behalf of everybody in the House. But but I also know that there are many professionals who also use narcotics, marijuana, casually and socially. Lawyers, doctors, you name it, business people, etc. They use it. And just like many other uh, drugs, they can create addictions, and it's no different in that situation than alcohol, which can also create addictions and have severe consequences as well. So I wanted to just frame the, this debate that we're having here and to explain that this enlightened position where we are allowing ourselves the opportunity to examine and re-examine the measures and the policy that has been implemented over a long period of time is important, especially when it comes to evaluating how best to chart and share the direction for young people and to protect them. For which many young people who may have experimented, they realize that this is not something that is good for them or they want to continue, and they leave it aside and they continue doing what they would have wanted to do in their life. But there are others where it severely impacts them. And I know my sister, Sheila, Honorable Member Sheila, would have shared in our meetings some of the horror stories that exist for some of the addicts. And when their families come to say how they have felt that they are losing them. Now, that is one of the reasons why the government of Guyana, this government of Guyana, did not want to go further and maintained the position that it remains an offense, a criminal offense. Those horror stories are real. Ask any family who would have experienced their son or their brother or their nephew, seen them grow up with them as a child, reared them, invested in them, built all kinds of stories and memories with them. And because of their addiction, it also became a horror story that they have to live with as well. And that's one of the reasons why when we hear those stories, it's not an easy decision for us. I have to very clearly call out the opposition in this situation, because just like every other important issue that we have had in this country, with the exception of the Deputy Speaker, the APNU AFC opposition, every other important issue, they have shirked their responsibility and they have betrayed the people of the country. They've had one contribution at the committee level, at the select committee, where they were suggesting that the possession of 3 kilos, up to 3 kilos, is what they would like to see in the law without there being an offense. 3 kilos is what they proffered as what they wanted to see inside the law, possession of it without it being an offense. Other than that, they had no contribution to this debate on a very important issue that affects the country and affects particularly young people. They have 3,000 grams, 3 kilos, on a very important issue for which affects young people and for which requires the leadership of the country. Leadership that they willingly undertook. They left. They disappeared. The country is taking note. I wanted to come to share my views on this, as well as some of the important facts in relation to the debate on the possession of marijuana and the use of marijuana. And it's something that we on the government side of the house, we take very seriously. It is a commitment that we made on the solicitation of many, many young people all across the country while we're in opposition and even before that. And I have, and for everything that I have outlined earlier, Mr. Speaker, this bill, this amendment has my support. Thank you very much.
Thank you very much, Honorable Member. And now for the Honorable Member, Mr. Sanjeev Dattadin.
Good evening again, Mr. Speaker. Oh, it's still evening. Somebody in here smoking.
Why it has to be smoking in here?
Mr. Speaker, the subject of this debate makes me think. There's a saying that my dearly departed mother used to say, that no good deed goes unpunished. Mr. Speaker, the issue of cannabis, marijuana, ganja, has so been referred to, romanticized, put in songs, films, stories, and I'm sure every member of this house has a story which they've either experienced or been told about that involves the subject of cannabis. They are slogans, popular slogans with celebrities worldwide about legalizing cannabis. Well, Mr. Speaker, we have to live in the real world. In the real world, consensus is important. Governments should be instruments of the wishes of the people, principally. They should govern in a responsible way, but they should also pay heed to the wishes of the majority. It's the foundation of democracy. So, in this debate, it was unlikely that any one group would have their way. It turns out that perhaps no group would have had exactly what they wanted. But, Mr. Speaker, I believe that's because they did not see what was really the problem and what needed to be fixed. Mr. Speaker, we cannot keep imprisoning young people for the use of cannabis. And 30 grams is now the limit, for which there will be no imprisonment. The first 15, there's counseling. 15 to 30, there's community service. But we were all young at one time, and we all may or may not have made mistakes of varying degrees. Cannabis, given, as I said before, its place in popular culture and society, has been at least tried by most persons. And can you imagine the consequences and how different life would be if instead of going to the University of Guyana, you went to the University of Crime? Because that's what the prisons are. You would send young people who would have smoked a token amount of weed or cannabis and ended up in prison for 3 years because that's what the law said happened to you. A draconian and difficult law to explain at the best of times, and at the worst of times, a law that absolutely destroyed the lives of people, so many young people. So the focus, and this is what we have to look at, the focus is imprisonment is reduced. The focus is exposure to jail sentences is reduced. The opportunity for help is enhanced, and helping young people in an organized way is perhaps the best and most responsible way to steer them in a different direction. But there's the yin and yang of everything, and this one in particular has a lot. The downside of addiction is faced with the other side saying it's part of a religion. The crime that follows addiction and the sale of personal assets and family assets and achieving quote-unquote junkie status is met on the other side that they are medicinal benefits. The destruction of families on one side is met with the obvious health benefits, the alleviation of pain. Some people claim cure, but in many cases for persons who are terminally ill, it provides end-of-life care that would otherwise not be possible. These are real issues in a real world. And real issues have to be confronted by leaders. And leadership is how you navigate it. We can't all have our own way, Mr. Speaker, and we shouldn't. There continues to be, at one stage in the 70s, following what the Honorable Minister Ramson referred to as the psychedelics and the hippies, when the developed world thought there was just too much abuse of narcotics, so they criminalized it. It had not been criminal before, but they criminalized it. As a result of which, there was pressure on the developing world and the poorer countries to do likewise. That followed. Now the developed world is thinking, well, let's not criminalize it anymore. And there is, of course, pressure on the developing world to again follow. Criminalizing cannabis is entirely different from the punishment and the imprisonment that follows. It is a situation whereby you have to decide whether you simply want usage to go unchecked in a small developing country like Guyana, and whether we have the social mechanisms to cope? Or do you want to try to help persons who may be using? They fall under the criminal justice system. Under the criminal justice system, there is provision for treatment, there is mandatory counseling. The opportunities of help exist, provided for by the state. The opportunities for change would exist, one would have thought, and that would be obvious. The effect of narcotics, Mr. Speaker, can have catastrophic consequences. But if you were to decriminalize narcotics and allow persons to use it without supervision, without consequences, thank you, cannabis I'm referring to, and not the other ones. But if you were to allow the usage to go unchecked, then you really have no opportunity of regulation. Now, we may not be able to regulate the way the developed world do, with putting DNA markers in the plants that they plant and sell, a very expensive process. We might not be able to do that. But what we might be able to do is this. For the young people who may decide or may be using marijuana and they are caught, well, I don't want to say caught, when the police have put them before the courts as a result of it, there is now the opportunity for help. The real opportunity that help will get to them, and they can then take advantage of that. Now, we all know the counter argument, Mr. Speaker. It might make no difference. Now, that's a real possibility. But it's easy to say it wouldn't make a difference if you don't have to try. But try is all you can do in these situations. They can be very, very difficult to appreciate and very paralyzing for the people who are experiencing it, especially the family members. But, Mr. Speaker, this bill, stripped of everything else, simply seeks to reduce incarcerating our young people and incarcerating people who use marijuana. That's essentially what the bill is seeking to do. There is no decriminalization, as has happened in other parts of the world, because, as the Honorable Attorney General was at pains to point out, the wide consultations over more than a year, these are the views that have been received, views that are on both sides and views that are in the middle. This is the perhaps unhappy consensus, but consensus all the same. Mr. Speaker, anything that reduces the prison population is useful. Anything that reduces imprisoning young people, I think, is absolutely exceptional. And any chance that could be given, especially to young people, for the opportunity, any chance or opportunity to take a different path than the use of recreational drugs is, of course, in my mind, the absolute best that can be achieved. In those circumstances, Mr. Speaker, I support the Narcotic Drugs and Psychotropic Substances Control Amendment Bill of 2021, and I do commend it for passing to the House. Thank you.
Thank you very much, Honorable Member. Mr. Datadin, Honorable Attorney General.
Mr. Speaker, I rise to conclude this debate and to begin the conclusion of what has been a very long and exhausting day. I believe, Mr. Speaker, that we have set a record today in this House of debating to their completion 7 bills at one sitting of the National Assembly. I don't think any parliament has achieved such a feat in Guyana. And I want to thank all the speakers who spoke in support of all the bills, including the bill that we are currently debating. I just saw a statement from the leader of the opposition in which he makes a very clumsy attempt to explain their walkout, saying that the National Assembly is not serving the best interest of Guyana and Guyanese. Well, I wonder whose interest he is serving. He's not here, period. Simply because he didn't get a ruling in his favor in a palpably misplaced and inadmissible motion. He must have observed the amount of work that we would have accomplished tonight, and he must have received the adverse impact it is having on their political status quo. So belatedly, he comes up with an inexcusable and feeble explanation for their walkout. He also he blames the cost of living as well. He says he blames the rising cost of living for him walking out of the parliament. You got to actually read these things to believe them. But, Mr. Speaker, in the light of rising cost of living, and he so cares so much for the Guyanese people, rather than stay in this House and debate their business and represent their interest, he condemns them to further misery by drawing their monies and absconding his responsibility. Mr. Speaker, I want to thank all the members who spoke in support of this important narcotics amendment bill. It has been a very difficult task in explaining the balance, having regard to what we know are being expressed as different views out there. I want to thank the members of the Special Select Committee who worked assiduously in concluding the business of that committee. And last but not least, Mr. Speaker, the staff of the drafting department of the Attorney General Chambers must be recognized for their outstanding hard work in completing all these bills and making them ready for debate, and also for being with us and remaining vigilantly here with us at this unholy hour as we approach midnight. Mr. Speaker, with those few remarks, I move that the bill be read a second time. Thank you very much, Mr. Speaker.
Thank you, Honorable AG. Honorable members, I now put a question that the narcotic drugs and Psychotropic Substances Control Amendment Bill 2020, Bill number 2 of 2021, be read a second time. Those in favor say aye. Those against say no. Ayes have it. Let the bill be read a second time.
Narcotic Drugs and Psychotropic Substances Control Amendment Bill 2021, Bill number 2 of 2021.
House will resolve itself into committee to consider the clauses of the bill. Honorable members, there being no amendments to the bill, I will.
Mr. Speaker, if I may, might I inquire respectfully whether we are going to, there were amendments that were made and are in the report. Can I ask, for purpose of expediency, that we adopt the amendments made in the report, adopt the report, and incorporate the amendments in the report into the bill, and then we will do the tidying up.
Honorable Attorney General, there is a rule in terms of amendments to bills that we circulate them and consider them. I don't think it would be proper to adopt the report and allow us to. I would prefer we go through it. You propose the amendments, we deal with it, and complete the business of this bill.
Very well, Mr. Speaker.
If you can guide me with respect to which clauses we have to deal with, then I can so pause it. Or it's only 8, we can just take them one by one.
Clause 4.
Clause 4.
Clause 6. And then I see clause 6, subclause 4. And then subclause 9. Those are the amendments, based on my very peripheral examination of the report, the appendix of the report.
Honorable members, the committee report is at the House with amendments to the substantive bill that was tabled. And it's attached at the end, as the AG had correctly observed, at the end of the report. So, but I still want to see, this is not the report. This is, if I can see the report, we can deal with them quickly.
Mr. Speaker, the report was tabled on August the 8th in the House and circulated to MPs for this meeting.
Yes. Honorable Attorney General.
Sorry. Yeah.
Go ahead, Honorable.
Yeah, Mr. Speaker, I was trying to see if I could help. In the report, in the matrix, there's basically one correction that is repeated several times because the phrase is in the original bill, or the original bill that was brought to Parliament. So it's basically 1, 2, 3. That's it. And so it's not difficult to deal with. And maybe I can help my colleague if you allow.
Just give me 1 second, let me consult if I can put the bill as amended by the committee
By the report of the committee that's adopted.
be
Yeah.
adopted.
We can regulate our own business here, Mr. Speaker.
No.
Honorable members, having had the benefit of some more information and the report of the Special Select Committee having been circulated since August the 8th, I now propose that the bill as amended by the Special Select Committee be adopted. Honorable members, I now put the question that the Narcotic Drugs and Psychotropic Substances Control Amendment Bill 2020, Bill number 2 of 2021, the bill as amended be adopted by the committee. Those in favor say aye. Those against say no. Ayes have it. The bill as amended by the Special Select Committee, those clauses are now part of the bill. Honorable members, I now put the question that the bill as amended be reported to the Assembly. Those in favor say aye. Those against say no. Ayes have it. Let the Assembly resume. Honorable Attorney General.
Mr. Speaker, I rise to report that the Narcotics, Drugs, and Psychotropic Substances Control Amendment Bill 2021, Bill number 2 of 2021, was considered in committee clause by clause and was passed with amendments. I move that the bill be now read a third time and passed as amended.
Honorable members, the question I put is that the bill, the Narcotic Drugs and Psychotropic Substances Control Amendment Bill, Bill number 20 of 2020, Bill number 2 of 2021, be read a third time and pass as amended. Those in favor say aye. Those against say no. Ayes have it. Let the bill be read a third time.
Narcotic Drugs and Psychotropic Substances Control Amendment Bill 2021, Bill number 2 of 2021.
Thank you. Honorable Minister of Parliamentary Affairs, I see the report, the sixth report of the committee, the adoption of the 8th periodic report of the Parliamentary Sectoral Committee on Social Services.
Mr. Speaker, I would suggest that the reports, there are 3 before the House, be deferred to the next sitting, please.
Thank you very much. Honorable members, this concludes our work for this sitting. I now call on the Honorable Minister to move the adjournment of the Assembly.
Thank you, Mr. Speaker. I wish to adjourn the sitting to a date to be announced, assign a day. Thank you very much.
Honorable members, the Assembly stands adjourned to a date to be fixed.